Hello, everyone. So welcome to today's event, Article 2 Windsor Framework, Unpacking Law and Policy Challenges. So my name is Billy Melarouge. I'm a professor at the law school. Don't panic. I can already see the disappointment in your faces. I'm not David Finnemore. He is coming in just a second. Just to let the people know online, if you have any questions, ideally put them in the comments box so that we can avoid audio feedback. And I think actually you don't have the choice anywhere, so you're muted, which is not to say you're not welcome. That's just an IT issue. So that's all I have to say. And I'll let David take over.
Thanks very much, Billy. Welcome everybody to today's conference, particularly those here today, but also everybody online. I'm sure you can read what we've got on the slide there. The event today is taking place as part of a broader project which Billy and I have been working on, along with Lisa Claire Whitten and Katie Hayward, on post-Brexit governance NI, which was due to look at the multiple dimensions of the implementation of the protocol, now Windsor Framework, 4 years ago. I think we should have probably renamed it the project looking at the implementation and non-implementation of the protocol Windsor Framework. It's been a fascinating project for a whole variety of reasons. One, because of the interdisciplinary nature of the challenges which Brexit and the protocol threw up, particularly given the very unique arrangements which have been put in place for Northern Ireland in this process. And I think we've had a fairly enjoyable period over the last 4 years trying to navigate the ins and outs of the implementation process. And that's before you throw in the politics. Any research project raises lots of questions. I think it raises even more when you've got the political contestation surrounding it, which we've had. So it's been a fascinating period. It's been also fairly frustrating, I think. And I think that's possibly reflected in the handling of Article 2. Fascinating because of the arrangements which Article 2 provides for. Novel, interesting, lots of questions there for lawyers. But also, I think, possibly frustrating too. The fact that we are 4 years into this process where we've still got some dispute ongoing or contestation around what Article 2 actually means. I don't need to remind everybody that there's ongoing challenge to the meaning, understanding of Article 2. Nevertheless, it means we've got plenty of questions that we can discuss. Look forward to 3 panels today for the questions they'll raise, but also hopefully the discussion that they'll induce here. And obviously, as Billy said, encourage everybody to contribute because we will have Q&A sessions after each of the sets of presentations. And yeah, very much look forward to what everybody has to say today, the conversations that we have, and hopefully the ongoing discussions that will come out of the event. So, without any further ado, I'm going to hand over to Aoife and look forward to today's proceedings. Thank you.
Thank you, David. Hello, everybody, and everybody online. So I'm chairing the very first panel, and I'm really pleased. It's an excellent group of people. The end is going to be a surprise. So, you know, we've all been with bated breath as to the final speaker and who it might or might not be. So I'm sure, you know, you keep your anticipation going for the whole session. So I'm not going to do very long introductions to anybody because I think the expertise really stands for itself. And I don't want to take up their time. Thank you. I want to take up their time. So we're going to start with Professor Colin Murray from Newcastle University. The mouse that roared, Windsor Framework Article 2 comes into its own. So off you go.
Okay, everyone. Well, I was supposed to be following Professor Chris McCrudden in this, and he was going to do a lot of the fundamental legal rules around Article 2 and the setup. But as Professor O'Donoghue has said, there's been a slight change to running order with timings. So I'm now going to crowbar that in to bring everyone up to speed before trying to cover what I was going to talk about anyway. So I'm going to speak very quickly for the next 15 minutes. And I'm going to talk about, well, what David was saying in the setup here, that Article 2 is still seen in multiple ways. It is seen as being all or nothing, depending on who the viewer is. And whether it's really important or whether it's a minor feature that doesn't really have very much legal impact, very much changes from time to time and depending on who's speaking on it. And I think that's one of the most dangerous elements of this element of post-Brexit Northern Ireland. There were things that were agreed in the course of the withdrawal agreement that people thought were tied up and had pretty firm meaning, that there's now an idea of hollowing out. And there's danger in that, both in terms of reputational danger for how the UK government is approaching a lot of these questions, but also danger in terms of the stability of the constitutional setup in NI. And I want to try to tease those out, what's going on within this, or what makes it so open textured or capable of sustaining these different approaches, or at least sustaining them if you don't look closely enough at the question. So is Article 2 a mouse, or is it actually going to roar? I'm referring to to a Peter Sellers film from 1959 that no one but me will have seen, but it's really the beginning of Peter Sellers trying to do 6 different roles in a film. Think of it as prep for Dr. Strangelove. So, as I say, Professor McCrudden was going to set up this idea of what Article 2 was all about. And Article 2 has different obligations embedded within it. There's one set of obligations that are towards dynamic alignment. Law within Northern Ireland will fully track to EU law as it develops in the space of those 6 directives. So a central bit of EU anti-discrimination law, but by no means all of EU anti-discrimination law, and not everything that is relevant to rights or equality within EU law by any means. But there's also a second obligation, and it's sometimes called a standstill or a non-diminution obligation. And that's a law in NI will not go backwards commitment on the way EU law worked within the jurisdiction prior to the UK leaving the EU, prior to EU law ceasing to have effect in December 2020. So that's an obligation to EU law as it existed at a point in time. This is an obligation, dynamic alignment, to EU law as it develops in the future. And that relationship between these two kind of, well, it gives a variable geometry to Article 2 that sometimes can make this seem complex or complicated, but actually when you understand it and you see how it works and you translate that into a legal test, it's pretty workable. It's workable but complex. Complex here is not a synonym for confusing or unknowable. And I think sometimes Article 2 is being presented in that way. So when you look at the non-diminution obligation, if you look at the 2 obligations together, there's a core of what we know. The Annex 1 directives, Northern Ireland law has to fully track with those as they're amended or they develop. But then there's almost a penumbra beyond that. How far does Article 2 extend out? And the Human Rights Commission and the Equality Commission, set up as the dedicated mechanism under Article 2, Paragraph 2 of the Windsor Framework, have done a huge amount of work in fleshing out how far does that scope go. And that, if you like, has pitch rolled Article 2 within this jurisdiction. That work really matters because it set up the courts to understand, well, what are the limits of non-diminution? How does it work? What are the tests that go into it? And you can say, if there's an aspect of EU legislation that is in the rights or equality realm, and it can be connected to the rights, safeguards, and equality of opportunities chapter of the 1998 agreement, then you're in an Article 2 space. You need these two things together. And it's sometimes I've heard said, well, this has been some peculiar way to give effect to a bit of the 1998 agreement that didn't have legal significance to it. It wasn't the basis of actionable law. But that's just essentially a scope. It's not that this is being given direct legal effect, but Article 2 requires us to understand it only operates within a certain tapestry. And those elements of the 1998 agreement set out the borders of that tapestry within which this law now works. This isn't a backdoor way to put a full-fledged account of RSEO into domestic law. It just sets the template. If it's within this area and EU law worked before Brexit, the non-diminution commitment ensures that it continues to work. Now, it's not just that the Commission's fleshed this out. And this is a really important point because Article 2 can be overlooked. It's one of the great survivors of the Brexit process. It was there as Article 4 in Theresa May's draft withdrawal agreement. It was settled pretty early in the process of drafting Theresa May's withdrawal agreement. Why was it settled early? It was settled early because of this. Because you could connect EU law directly to how rights and equality worked in the 1998 agreement. After 1998, lots of this area of law continued to develop under the auspices of EU law. It was left to EU law to do that heavy lifting as to what elements of these commitments meant. So you could say EU law was real in this space and could be directly plugged into part of the agreement. So the UK government's mantra, we're going to achieve Brexit in line with the 1998 agreement, had a really hard-edged element. You could argue about the trade element and to what extent the 1998 agreement applied there. And let's face it, we lived through those arguments. But here, there was absolutely no doubt about this. And because of that, it almost hoved out of view. This was so uncontentious, or rather, it was not contentious yet. It was so settled that this applied in the context of the 1998 agreement, or could be directly linked to. But the UK government itself added to the work that the commissions have done to flesh out these arrangements. They put an explainer in place in August 2020 that started to say, what's in that space of non-diminution? The directives, the bits of EU law include, but are not limited to, the Victims Directive, the Parental Leave Directive, the Pregnant Workers Directive. We accept that Article 2 extends into these elements of EU law and protects them, and it starts to name them. Now, the Commission did the work of fleshing out that list and looking at other comparable directives to give a much fuller picture of that tapestry. But you look at the terms of the UK government's engagement with it, and it continued to come back to, we accept that certain directives fit clearly within this obligation. So when the Commission's raised questions as to how immigration law was going to apply post-Brexit, the UK government took a position. I don't think it's the correct position, but there's a core in it that it's not trying to get away from. Here's Baroness Williams, minister under the last government. Given the general application of the Victims Directive is relevant for the purposes of Article 2, we accept that, but only we think insofar as the rights of victims of conflict-related violence in Northern Ireland under RSEO. They were trying to give a conflict-hinted approach to what RSEO meant, whereas if you go to the text of RSEO, it talks about the rights of everyone in the community. It's about moving on from a conflict. It's about saying, this is the new Northern Ireland we are going to found, and we are founding it on the basis of rights for everyone. But even within that caveat, there's an acknowledgement of how this applies. There are expectations as to how this will work that were generated by how the UK government was approaching it. And those expectations then ran headfirst into reality as the UK government started to try to do things post-Brexit. The whole idea of Brexit, take back control, can be boiled down to, we want to do things that EU law stopped us from doing before. And in spaces like immigration, that's the Qualifications Directive, it's the Procedures Directive, it's the Trafficking Directive. In spaces like the UK government's Legacy Act, that's very clearly the Victims Directive. And this was not a surprise. The UK government was acknowledging Article 2 would work in this way, but when the rubber hit the road and it wanted to do things, suddenly its Article 2 obligations were mutable, or hopefully forgettable. When we got to, not even a year ago, 11 months ago, paragraph 46 is safeguarding the union. The government's unambiguous position is the Windsor Framework is not engaged by immigration policy. Article 2 of the framework doesn't apply EU law and only works with regard to the rights, safeguards and equality of opportunity chapter of the 1998 agreement. This element of the Windsor Framework is all about trade, and it's limited in its scope. Now, I'm going to use the following image advisedly, and some of you have seen it in my presentations before. What Article 2 is doing is a tether. And it was once presented by unionists in the context of the Home Rule crisis of 1912 to 14, that law on this island would disappear, would drift away. Some of the historic rights protections would go if Home Rule was provided. And the idea of not allowing Home Rule tethered this island to common law rights. This image is now reversed, because if Article 2 imposes a higher baseline of rights protections by comparison to what's at work in GB, well then the only quote unquote unionist solution to Article 2 of a UK government that advisedly takes that approach is to level up law in GB to meet these requirements. If it wants to have all UK law, it has to meet the minimum rights baseline. And the minimum rights baseline is now set by NI, by the special rights protections it is given in this context. Now, Professor McCrudden was going to talk through the SPUC test. It's the translation of Article 2 into a set of legal rules. And again, yeah, Article 2, you might have said, wasn't perfectly clear when it was drafted how the courts were going to use it. But it's erroneous to continue to call it unclear, because the courts have spelled out how they work through this process. And you can take the SPUC test, it's 6 elements, and break it down into 3 parts. Is the 1998 agreement engaged? Is it within the scope of RSEO? Was there an EU law operating within that space? And has that EU law been diminished as a result of Brexit? So after Brexit, is the UK trying to move away or reduce those standards to take back control in the face of what EU law required? Now that's really come up in the context of the Dillon case and NIHRC's action over the Illegal Migration Act. I'm going to very quickly take you through some elements of it, because it's really important to see what the UK government is trying to backtrack on. In NIHRC, there was an effort to say, well, Article 2 doesn't really even exist. It's argued by the UK government that these elements of the 1980 agreement are not made applicable, but they really set some sort of vague benchmark by which rights can be measured and no diminution ensured. It's what the UK government keeps talking about as an obligation of result, without really saying, well, yeah, but that still guarantees our result at the end of this process. But as Mr. Justice Humphrey said in this case, any element of EU law made applicable produces the same effects in the UK as it does in EU member states. Natural persons can rely on this, including by direct effect. The UK government was trying to get out of the commitments it had made around Article 2 having direct effect in the 2020 explainer and in ministerial claims. And the Northern Ireland Court said, you're not going to be able to back away from things that you had promised. In Dillon, things reached the same, almost reached fever pitch around this. There was a doubling down of the effort to backtrack on direct effect. And there the Court of Appeal really looked askance in this. We're looking at a submission here that's at odds even with the written case. The UK government was trying to say bits might have direct effect, and then the UK government's counsel was standing up and saying none of this has direct effect. This was a mess of an effort to backtrack on things people thought were locked down. And in a post-conflict society, you cannot make a series of pledges about how an area of law is going to work and then seek to backtrack on them and be regarded as a good faith actor by people within that space. Is an RSEO right engaged? In Dillon, the court was really clear on that. Victims were explicitly covered in the RSEO chapter of the 1998 agreement, and now the Victims Directive is seeking to be removed in its effect by the operation of this law. There's a really interesting element of counterfactual. What if the NI Bill of Rights, drafted in 2008, had taken effect? If it had come into effect, there were large elements of it that covered the rights of victims. And had those elements of the process of completing rights embeddedness been in place, well, then the Legacy Act would have run headfirst into those. The UK government would have to say, we're repealing bits of the NI Bill of Rights to get this passed. But instead, it's trying to do exactly the same thing with regard to EU law and the Victims Directive. Then, is RSEO engaged? For NIHRC, there's an attempt to take a really limited approach to what was meant by rights under the agreement. There's an effort to say all of this is just about, well, there's constructive ambiguity, it's part of lengthy negotiations between political parties, it's all just about reconciliation, about a two communities narrative here. Mr. Justice Humphrey said, no, the agreement says it's about everyone in the community. This isn't just about settling the conflict, and people who are asylum seekers in the space of Northern Ireland are within the community. This cannot just be seen as being an orange and green set of issues. Now, I'll flick through the bits of the presentation that we're going to cover the actual meat of how these tests work, because again, Professor McCrudden is going to come later to discuss those. But what about the consequences? Well, if there's a breach, then that leads to disapplication. This was known when the UK was an EU member state. You're bound by your EU law obligations. You can't pick and choose within them. If you're a member state and an EU measure has direct effect or direct application, you're bound by those terms. The effort to get around that, or to say, oh, we shouldn't apply disapplication here, was an effort to deny the reality of what these measures are post-Brexit and the way that it was locked in. But the sum total of what the UK government is doing and trying to backtrack on so many of its commitments came just earlier this week on the tobacco directive and the efforts to limit access to tobacco and vape products in the tobacco and vapes bill currently before Parliament. Jim Allister asked repeatedly the awkward question, how does this new bill square with the tobacco directive? Now that's not covered in Article 2 and Annex 1, but it is covered in Annex 2 and Articles 5 to 10. But why did Jim Allister ask this question? We said, we were told before EU law wouldn't apply in the Legacy Act or under immigration legislation, and it's been shown to be false. And what's been the UK government's response? It is a one line, we are assured by our lawyers that this is not covered. And that assurance, Jim Allister is right, is not adequate in this space. We exist in a time where the UK government's commitments have been seen to be mutable, have been seen to be, well, removable at will by that government. And the whole idea of, oh, our legal advice is protected and we're not going to bring this into a public domain is not credible anymore. The UK government needs to move into a space where it is upfront both with itself and us about the implementation of the Windsor Framework. Thank you very much.
Thank you, Colin, and thank you for doing half of Chris's paper and half of your own paper as well, which was very useful. So we're going to move now, and I think I think the two papers actually will complement each other quite a lot. So next we have Tywin who's with the Northern Ireland Human Rights Commission, and she's going to talk through a practical guide to litigating Article 2, which I think is a really useful way to think about everything that Colin just set out about kind of the realities of how this is now happening on a day-to-day basis in different solicitors and barristers' offices across Northern Ireland now. So. I'm sure. Would you give the clicker, Colin? Oh.
Good morning, everybody, and thank you for that really wonderful introduction into Article 2. Colin, that was really helpful, I think. So today, I'm just going to talk about the practical steps in litigating Article 2. It's a really exciting and new area of challenge. So for anybody who is considering a challenge of this type, hopefully you'll find this presentation useful. So this is just a quick overview of what I propose to go through today. So just some procedural steps in how to bring a judicial review in this area, and then some takeaway from some recent cases. And then finally, just some considerations over whether you would want to bring a challenge under ECHR or Windsor Framework Article 2 grounds. So a challenge based on Article 2 of the Windsor Framework is brought by way of a judicial review. So I want to talk briefly about who can bring such a challenge. In terms of standing, this is different to the requirement of victim status that we are probably all familiar with under the Human Rights Act. So for the purposes of judicial review for Windsor Framework, it's not victim status, but it's actually having a sufficient interest in terms of standing. And that's set out in Order 53, Rule 3.5, or the rules of the court. So that states a court shall not grant leave unless it considers that the applicant has sufficient interest in the matter. And what do we mean by sufficient interest? So sufficient interest means that you're not just a busybody. So Lord Reid, very helpfully in the case of Walton and Scottish ministers, set out that it makes reference to somebody who's not a mere busybody, and that's somebody who would have no legitimate concern in that matter. So Obviously, someone we would never know, someone interfering without any legitimate concern in anything, but it is fact specific. So it really depends on the case that you have and the evidence that you have before you, whether you do satisfy that standing. So once you've established standing, the next step for you is whether you can satisfy the test for leave, and that is an arguable case with a realistic prospect of success. That is quite a high bar, so it's really so you're not wasting court time with vexatious claims or things that don't really have any evidence to back anything up. So you want to think about how are you going to meet this test for leave, and the test really then is you should be addressing, as Colin has already set out, the six-part test in SPUC, which we all have come quite familiar with, those of us who have been looking at this Article 2 for a long time. So in your pre-action letter and subsequently in your Order 53, you should be addressing how your case meets the test for leave, and that's the six-part test in SPUC. So once you have all that established, once you start contemplating judicial review under Windsor Framework grounds, the same procedure will apply as for any JR currently, and that's the procedure set out in Practice Direction 2018. So the first step in any judicial review is going to be your pre-action letter, and this is going to set out the details of what you're challenging, the facts, why the provisions or the decisions that you're challenging are wrong, and what remedy that you're seeking. So once proceedings start, parties do tend to forget about the pre-action correspondence, but it is really worthwhile spending time on this part because this is the first time that you will get an indication of what the arguments against you are going to be when you get your response to your pre-action letter. And this is then going to start the ball rolling in terms of what evidence you are going to need to progress your challenge. And I can't stress how important it is to get the right evidence in place. There is no point putting in a really fantastic legal argument if you don't have the evidence that there is a diminution of those rights. So this evidence is going to form an essential part of your grounding affidavit. And the sooner you start thinking about the evidence that you need, the better. So also, if you do require legal aid, the letter, your pre-action letter and the response is going to be a crucial part of how the Legal Services Agency is going to determine whether they're going to grant public funding for your case. So it's really worthwhile putting in a strong pre-action letter right from the beginning. So there is a 3-month time limit to initiate proceedings. The court does have a discretion to extend that time limit in very, very limited circumstances. Judicial review is really about fairness to all parties and managing the court's resources properly. So it is always good practice to make sure that if you are initiating proceedings, you do comply with that 3-month time limit. There may also be devolution issues to consider. So you may want to draft a devolution notice. A devolution issue is where a devolved body is going to be acting or proposes to act in a way that is incompatible with convention rights or community law. So it's going to be very relevant consideration for Windsor Framework challenges. There's also talk about a practice direction about giving notice where there is an Article 2 point, but we're not quite sure what form that will take or who the notice parties will be. So that's something to consider as well in the future in this area of litigation. So hopefully you've got all these in order and you'll all be on your merry way to establishing a breach of Article 2. So I'm going to just turn to some of the cases. The first case I want to discuss is the Illegal Migration Act challenge, which the Commission brought using our own motion powers. So the purpose of this act was to prevent, deter unlawful migration by removing UK certain persons, reading, essentially just about everybody who enters to claim asylum, who enter or arrive in the UK in a breach of immigration control. The Act received royal assent on 20th of July 2023, and the Commission had lodged proceedings by the end of September, so well within the 3-month time limit. This challenge centered around various provisions contained in the EU asylum acquis that the UK government had signed up to prior leaving the European Union. And if the IMA provisions had come into force, then they would have, the Commission's stand was that they would have constituted diminution of the rights contained in those relevant EU law provisions that were under challenge. So these were the EU law provisions that the Commission relied on: the Procedures Directive, Qualification Directive, Trafficking Directive, and the Charter of Fundamental Rights. So you can read up about all these procedures later on. I don't want to take up too much time explaining those. In terms of the grounds of challenge, there are the various heads of challenge. So admissibility, removal, non-refoulement, detention, removals of victims of modern slavery, removal of children, and also effective remedy as well. So I want to make a practical point here about your skeleton argument and just some advice on how to draft that. It's a really, really complex area of law. It is very new. There's lots of new jurisprudence. If you are struggling to follow this talk, it's not my poor presentation skills. This is just very, very complicated. So it's important that your skeleton argument sets out a clear analysis of the law. It's structured in a way that's going to assist the court. So in a presentation earlier to the Law Society earlier this week, Justice Humphreys, who was the judge in this case, was and the keynote speaker, he was very complimentary about the Commission's skeleton and did say that it was the first to really set out Windsor Framework arguments properly. It's well structured, a really detailed analysis, and it was really of great assistance. So a hint there is really just set out and draft your skeleton the way you would like the final judgment to read. So in this case, it is a really excellent judgment to read in terms of if you want to litigate in this area. It will help you guide and set out how you should be structuring your arguments. But essentially, in the judgment, Justice Humphreys helpfully set out how the provisions of the withdrawal agreement, Windsor Framework, Section 7 of UA 2018, and the Charter all came together, really. And in particular, he did, as Colin has already set out, that civil rights did extend to everybody in the community, and that the Charter continues to have effect in Northern Ireland by way of Windsor Framework Article 2. So he reasoned that although there was no mention of immigration or asylum in the Good Friday Agreement, it did contain that specific commitment to the civil rights of everyone in the community. And the government had argued that those rights should have been limited to healing sectarian conflict resolution, really limited to the Troubles. That was rejected by the court. And in this case, and in the Court of Appeal, in the Dillon, the legacy case, they found that civil rights should be interpreted very broadly and encompass the political, social, and economic rights of all. So therefore, in this case, the court determined there was no reason to exclude the rights of asylum seekers. And then the decision of the High Court went on to hold that there was a breach of ECHR in Article 3, 4 is related to trafficking, and 8, and also a number of provisions regarding a breach of Windsor Framework Article 2. And he made an order at that stage that the correct remedy was the disapplication of those offending provisions. So the court reasoned when applying the test in SPUC that each of these rights were protected by a relevant chapter in Good Friday. These were given effect in Northern Ireland prior to 31st of December 2020, and they were underpinned by the EU law that I've already set out. And when the UK left the European Union, this EU underpinning was removed, and that the IMA would cause a diminution of these rights, and it would not have been allowed pre-Brexit because EU law would have been supreme. So turning to remedies, Dillon and the Commission's case in IMA confirmed that where there is a breach of Windsor Framework Article 2, the remedy is disapplication. So Justice Humphreys has stated that in circumstances where domestic law is inconsistent then that domestic law is disapplied and confirming the supremacy of EU law. And very helpfully in that judgment, he said that was the will of Parliament, so it wasn't a case of courts overreaching themselves. So that differs to a breach of ECHR, where you get the declaration of incompatibility. With Windsor Framework, you are getting a more powerful remedy because you're not having to wait until Parliament goes back and amends the legislation in a way, and it could be a way that still is not compatible. So this means that the provisions themselves still remain on the statute book, but are not applied in Northern Ireland. So important to note as well that disapplication only applies in Northern Ireland, not the rest of the UK. So don't forget also in your Order 53, in your pre-action letters, when you are writing the remedy, you do set out the remedy that you're seeking is disapplication. I've just set out Article 47 of the Charter there. It's just as a point of interest, the right to effective remedy. That is a useful part of any grounds of challenge, particularly if an Article 6 ECHR ground may not be forthcoming. So you may explore using the 47 Charter right instead. The case I want to refer to next is Shima Ishmael. That's really the application of how the Charter of Fundamental Rights really ties into all of this. So in this particular case, the applicant here was originally from Sudan and was challenging the lack of a route by which her family members could join her in the UK. And she argued that her right under the Good Friday Agreement had been breached pursuant to Windsor Framework Article 2. She relied solely on Charticle, not Charticle, I'm trying to, yeah, it's a bit like Brexit, I'm trying to put all the words together and save some time. So she relied on the Charter grounds, Article 1, 2, and we can see they're very, very similar to your standard ECHR rights. And what Justice Humphreys did in this case, so first of all, he didn't dismiss this challenge. And we see that Justice Humphreys was very critical of the lack of analysis of how these rights were breached within the evidence that was provided. So going back to how important evidence is in judicial review. He's also very clear that the Charter is not freestanding, rights that can be relied upon within the confines of Article 2, and that there had to be an EU underpinning law, and without any EU law that was referenced and relied upon, the claim just on the freestanding Charter rights must fail. So the next two cases I want to look at, and the last two ones, are really just highlighting how those of you who are considering a challenge under Windsor Framework Article 2, how you might go about considering whether it's a Windsor Framework challenge or an ECHR challenge. So the first case is actually an Irish case. So it was brought by the Irish Human Rights and Equality Commission with regards to failure to provide accommodation for people seeking international protection in Ireland. So that's asylum seekers. This case concerned the 2013 Receptions Directive, which provides for minimum standards for living conditions for people who are seeking asylum. So just to remind everyone, Northern Ireland didn't sign up to the 2013 one, but had signed up to the previous incarnation from 2003. So those provisions are very similar. So the analysis should still be relevant for us. So under this directive, when a member state receives a person seeking asylum, they must provide certain conditions, including housing, food, clothing, etc., and a daily expenses allowance. And what was happening was that in Ireland, for a period of time, people were arriving seeking international protection, and there just wasn't any accommodation available. So as an alternative to accommodation, people seeking asylum were getting an increase for living expenses. They got an increase of 75 euros compared to people who had accommodation provided. So it just went up to just under 114 euros per week, which sounds like a lot, but I think anybody would appreciate somewhere like Dublin, that is not going to get you very far, even in a day, let alone a whole week. And a one-off supermarket voucher of 100 euros. So what the Irish Commission argued was that these conditions or the provision of the allowance was still not enough to meet the basic needs of asylum seekers. And it wouldn't even cover the most modest of temporary accommodation for a few days, let alone a week in the private rental market. And other considerations in the private rental market, you have to have a bank account, you have to have references, things that just weren't accessible for people seeking asylum and newly arrived. So this case really revolved around the definition of basic needs. We have jurisprudence from the Court of Justice, quite clear that a failure to provide for basic needs of applicants amounts to a breach of their right to human dignity. And the Irish court, in this case, went on to make a declaration that by failing to meet the basic needs and leaving applicants for international protection without accommodation or the means to access accommodation meant that the state had breached the rights of those persons as provided for under Article 1. So I want to just quickly then now refer you to the case of Re Mahmood. This is a case from the High Court in Northern Ireland. So this is actually a case, the crux of the main point of this case was about further submissions in support of fresh asylum claims for this applicant. However, during the course of these claims that the applicant was making, he made a renewed claim for asylum support, which wasn't processed due to technical difficulties. So that left the applicant without any recourse to any kind of public funding and destitute for a number of months. And in that time, he suffered depression, anxiety. I'd really suffered as a result of this error. So this case was appealed on other grounds to the Court of Appeal, but not on this particular point where the High Court held that the lack of asylum support was a breach of Article 3 ECHR. So you've got sort of two very similar factual circumstances, but this is approached from Article 3 and the other was approached from an Article 1 Charter point of view. The applicant in this case was subsequently awarded damages under the Human Rights Act for that breach of Article 3, which amounted to approximately just under £2,000. So in terms of, in summary, whether you may want to consider what grounds you may want to bring a challenge under. So it's just a recap of the considerations that you may want to look at depending on the facts of your particular case. Obviously, if you have both grounds, that's fantastic, like the IMA case, but sometimes that just might not be your circumstances. So first of all, the consideration would be standing. Is it a case of sufficient standing, which may be easier for public interest groups to surmount, and also whether you have victim status. So what kind of standing do you have? Also, your actual grounds. So Windsor Framework is going to have a different body of EU jurisprudence that you may be able to rely on with additional help from the Charter as opposed to ECHR jurisprudence. Oops, sorry. And then the remedies. So where legislation is challenged under ECHR, you'll get a declaration of incompatibility, whereas under Windsor Framework, you'll get the remedy of disapplication. And then you may also want to think about damages. So as we've seen, you can get damages under Human Rights Act for a breach of ECHR, but often those damages are quite limited and they have to be in accordance with the jurisprudence in Strasbourg. Or there could be the possibility of Frankovich damages under a breach of Windsor Framework Article 2. So UA 2018 did exclude Frankovich damages, but just like the way it excluded the Charter, it could be brought back in, and the courts have not stated that it's not a possibility. They seem to be quite open to that, so it could still be brought back in the contrary pipe of Section 7A. So hopefully that was useful for anyone contemplating litigation in this area. And if you have any questions, please feel free to raise them later today or to contact us at the Commission.
Surprise change, the running order. You might have noticed us all kept looking at the door and it opened. So apologies to anyone who came in. That's why you all got stared at. It wasn't to do with who you are. But thankfully, we have the great Dr. Lisa Clare with me, who's going to talk to us about non-diminishing dynamic alignment and cooperation, exploring the potential protocol on Ireland, Northern Ireland to protect the environment. And I'm sure we will be graced with Professor McCrudden's thoughts later on, later on. Or maybe not on, we'll be waiting a long time. But thanks a million to Lisa Clare for being so accommodating.
And I actually think there'll be more crossover between those two presentations. So it's all gonna work together seamlessly.
We're all about the synergy.
All about the synergy. Yes. Okay. Hi. So the purpose of this paper is to look at the relationship between Article 2 of the Windsor Framework and environmental protections in light of the 1998 Belfast Good Friday Agreement generally, and its rights, safeguards and equality of opportunity section in particular. It is based on what has at times felt like a never-ending piece of research, collectively carried out by myself, Ciara Brennan, Mary Dobbs, Alison Howe and Orla Kelleher on behalf of the Northern Ireland Human Rights Commission, who commissioned the work, which also means that there's some in the room who've had to read various versions of this research, for which they deserve admiration and a lot of sympathy. This presentation will give like a snapshot of what we've been looking at, and sort of take us halfway through the thought experiment and explorations that have taken place through this research. Think of it as like a movie trailer rather than the full film. For that, hopefully the full report will be coming in a not too distant. So core to this research is the question regarding whether and to what extent does Article 2 of the Windsor Framework provide meaningful protection for environmental human rights and or other human rights that could be used to protect the environment. I get that it might be a little bit of a left field approach to this, but hopefully by the end of this year, you'll be on board with the potential, at least for the interaction between all these elements. In order to start addressing this issue, I think it's useful and necessary to sort of unpack some contextual factors before we get to the actual Windsor Framework Article 2 element. So I'm going to step through some of those and then conclude by presenting in brief our high-level assessment for the potential for Windsor Framework Article 2 to operate in the field of environmental protections. Spoiler, there is potential. So in terms of just contextual elements here, before we start addressing this, we need to first think through the role of the environment and the position of the environment in the 1998 agreement. Also the impact of Brexit on environmental governance in Northern Ireland and on the island of Ireland. And then also what's happening in the field of human rights and environmental protections more generally, which we'll get to sort of indirectly in the later stage. So if you forgive me, some of this is going to feel like, why are you talking about it? But hopefully by the end, we'll all synergy will come through. So 1998 agreement and the environment. While of course, the 1998 agreement is a peace agreement, it does contain numerous important provisions from an environmental perspective, which aim to create the conditions for cross-border environmental cooperation. The environment is understood in the text as environmental protection, pollution, water quality and waste management, and it's expressly listed as an area for cooperation in strand 2 of the agreement, and therefore in the remit of the North-South Ministerial Council. The environment is also directly relevant to, I think we said 7 of the 11 listed areas of North-South cooperation, including, as you can see, waterways, agriculture, etc. And it was also named as one of the areas for the British Irish Council to focus on and consider as a an issue to cultivate cooperation on between the jurisdictions within the British Irish Council. So there is an environmental thread in the 1998 agreement, if you will, and it's if we are going to interpret the agreement in a generous manner, the environment and environmental cooperation is part of the wide vision for a new Northern Ireland, as Colin mentioned. So notwithstanding this environmental thread, it's fair to say that the potential for the agreement to act in this field has not been realised, or at least not fully in the 26 years since its implementation. In this respect, repeated collapses of Strand 1 of the agreement have not been helpful in stymieing the potential of Strand 2 bodies and the North-South Ministerial Council to take forward substantive cooperation in the environment and other priority areas. That's not to say cross-border environmental cooperation hasn't happened, but rather to note that the primary means by which it hasn't been through the mechanisms of the agreement, notwithstanding the potential that the text holds and the vision that it represented holds. So prior to Brexit, the unmet potential of the 1998 agreement wasn't, in respect to the environment, wasn't a major concern or focus, not really an issue. Why? Because the EU provided a broad and strong foundation for shared minimum level of environmental standards and cooperation between Ireland and Northern Ireland. So the full realisation of the 1998 agreement potential wasn't really necessary, which gets us to Brexit and the environment. So these shared EU foundations included a general sort of direction of travel, forgive the small print, via the continuously developing section of the EU acquis devoted to environmental standards, particularly referenced in the Treaty Article 191, which sets out an objective for Union policy on the environment to contribute to preserving, protecting and improving its quality, protecting human health, and then it gets on to a high level of protection and taking into account the diversity of situations. So we have this shared direction of travel via the EU that both Northern Ireland and Ireland are involved in to improve the environment generally understood. This also led to a whole stream of secondary EU legislation related to the environment, which no doubt you'll have some familiarity with the Water Framework directives, the Habitats directives, the birds directives, all sorts of EU red tape in the Brexit language. But we also had, importantly, in this context, governance mechanisms for enforcement in respect to environment. So the European Commission playing an important role in this, and also CJU jurisprudence developing alongside the parallel development of the EU environmental acquis. EU funding as well played a significant role on the island of Ireland in this respect, because environmental cooperation and protection was an explicit aim of it, and targeted and supported schemes that sought environmental improvement, which did play out quite a lot on the island of Ireland. So taken together, we have an EU-derived minimum level of environmental protection pre-Brexit in both jurisdictions on the island of Ireland, and with facilitation for cross-border cooperation through both regulatory alignment in this area and also specific EU funding for transboundary projects. All of that said, this is not to portray a sort of perfect picture or rose-tinted or green-tinted glasses. Environmental protection and cooperation was far from flawless on the island of Ireland pre-Brexit. There's long been significant environmental governance challenges in Northern Ireland: illegal dumping, cash for ash, ammonia pollution. Don't really need to convince you of that. Both Ireland and Northern Ireland have also been subject of EU enforcement action for non-implementation of environmental obligations under EU law. Imperfections notwithstanding, the EU had provided a valuable support system, governance structure that mandated regulatory alignment in these areas of environmental protection to the extent that they're covered by the EU acquis. So shared membership was unquestionably a net positive for the environment on this single biogeographical unit that we're all in right now, the island of Ireland. And Brexit, therefore, can be said to, at a basic level, pose a challenge to the continued development of environmental cooperation and increase the likelihood of governance gaps and unhelpful regulatory divergence across the island, with an anticipation for some level of degradation in the standard of protection in both jurisdictions, intentional or otherwise. So this begs the question, what tools were available post-Brexit to help maintain levels of environmental protection that currently exist on the island of Ireland, or to strengthen it? And it's worth very briefly just noting that there are vague commitments in the Trade and Cooperation Agreement. Vague is maybe harsh, but there is an overarching commitment for both parties to have a non-regression principle in respect of the overall protection for the environment, but this and other specific and potentially relevant TCA commitments, they are broadly drafted and are likely to be very difficult to enforce. In Northern Ireland, however, we of course have the 1998 Agreement and the Windsor Framework, the objective of the latter being to protect the former in all its dimensions, including environmental thread potentially. So here we get to the real substance of the work. As will be familiar by now, Windsor Framework Article 2 in all its glory sets out a very novel provision regarding rights of individuals after Brexit. As indicated, Article 2.1 creates a non-diminution guarantee that covers the rights, safeguards and equality of opportunity protected in the 1998 Agreement, and prohibits any such diminution resulting from Brexit, while its lesser discussed Article 2.2 complements this by requiring the UK to continue to facilitate relevant 1998 Agreement bodies in their related work, including but not limited to the Commission's European Quality Commission for Northern Ireland Human Rights Commission, and the Joint Human Rights Commission's Committee. So in approaching the 1998 Agreement and Windsor Framework Article 2, this paper and the underpinning research endorses a purposive approach. This is in line with customary principles of international law, as well as being reflected in the Vienna Convention. It's also in keeping with the view of the courts in the legacy case rulings most recently, where they adopted and advocated a generous and purposive approach in the interpretation of Windsor Framework Article 2 and corresponding provisions in the RSEO section of the 1998 Agreement. Notably, also, this work draws on the 6-point test, which I believe Professor McCrudden will address in detail for engaging Windsor Framework Article 2, and as has already been set out. The research also, potentially controversially or a point for discussion, does express some concern about the potential for the SPUC test to be used unnecessarily narrowly in certain circumstances, and therefore, proposes caution in some respects in its use. In particular, in this aspect, the SPUC test mentions rights and equality of opportunity provisions and doesn't include safeguards, but in the realm of the environment, safeguards, environmental safeguards in the 1998 Agreement are relevant. So we just sort of flag that as an option that is in keeping with the most recent Dillon ruling that advocated the use of the test as interpretive aid rather than a binding rigid code. So it's not to disagree with it, it's just to flag its potential in this space. So then in terms of scope, the non-diminution guarantee of Article 2.1 is largely determined by the RSEO section, as we've also already heard, which lists these rights in a further subheading of human rights. And I'm trying to skip through to save time. In particular, the use of the word in particular here we highlight because in looking at this section, the environment isn't obviously in there. But we would suggest a strong case for looking beyond these listed rights on the basis of a purposive and generous interpretation, but also on a textual reading in view of the qualifier of in particular, which indicates that this section protects more than just the rights listed. Indeed, we also argue that environmental rights and protections can reasonably be considered in scope of the RSEO section on the grounds of a purposive approach. And I'll just step us through the thinking that we went through. So first, some general points. In international human rights law, the concept of indivisibility of human rights would support the notion that if the listed rights are to be given effect in a meaningful way, they're likely to require other supporting and complementary rights and safeguards, including, for example, environmental rights and the guarantee of a healthy environment. Further, in the field of environmental protections, an ecosystems approach would provide a foundation and justification for a broad reading of this section in the field of the environment, in so much as it advocates and emphasizes the interrelated reality of nature in all aspects of ecosystems and therefore the environment. For example, you protect hedgerows, protects birds, but also protects soil, protects healthy water quality, potentially ensuring water is safe to drink, and for marine life, and therefore the production of food and ecosystem and economic activity. So from this view and these views, rights regarding life and economic activity can reasonably be considered contingent on a healthy, sustainable and resilient environment. On top of those more theoretical grounds, for a more generous and environmentally inclusive reading of the RSEO section, the idea of this section, that it was the starting point for human rights protections in Northern Ireland, is arguably clearly evident in the requirement therein for the incorporation of the ECHR in NI law and the intention for an NI Bill of Rights to be developed. And I'll come back to that in just a second very quickly. In the RSEO section, we can also identify environmental safeguards, for example, the obligation for the UK government to develop a regional development strategy for protecting and enhancing the environment, as well as developing the resources of rural areas. A case can be made that those specific environmental safeguards are complemented by a range of procedural rights, such as the right for freedom of political thought and the right to pursue democratically national and political aspirations, which, though explicitly orientated towards democratic and public participation rights, in application, they can also act as important tools and safeguards for promoting and strengthening environmental democracy. Similar argument could be made for the potential applicability of environmental protections of named rights, such as the right for equal opportunity and social and economic activity, regardless of demographics. A healthy environment can be a necessary condition for fulfilling those rights in certain circumstances. Taking the argument further, and then I'll skip through to finish off. As already implied, the required incorporation of the ECHR in Northern Ireland law can be said to indirectly affirm an environmentally inclusive interpretation of the RSEO section. Even though the ECHR doesn't explicitly guarantee a right to a healthy environment, crucially, the European Court of Human Rights has developed an extensive and growing body of case law on environmental degradation by greening existing convention rights. In particular, cases in this field concerning environmental pollution and degradation tend to address Article 2, the right to life, and Article 8, the right to respect for home, private and family life. Several positive obligations have been identified by the court in this field, including ranging from procedural obligations to grant access to justice on environmental matters, and also grant access to information on environmental issues. And also substantive obligations like a duty to put legislative and administrative frameworks in place to minimise environmental risk by regulating the licensing and operation of hazardous activities. Most in a sort of landmark ruling in April 2024, the case that I can never quite pronounce the name of, Varen Klimasenioren, Swiss, is that right? Where the Swiss government was, I'm looking at David, who's a German speaker, the Swiss government climate policies were found to be in violation of human rights and Article 8 of the European Convention, which the court ruled created a positive obligation on states to protect their citizens from serious adverse effects of climate change. The court stated that parties to the ECHR are required to put in place relevant legislative and administrative frameworks designed to provide effective protection of human health and life. Bringing it back to Windsor Framework Article 2, notwithstanding a growing body of green rights case law, states subject to the ECHR still enjoy quite a wide margin of appreciation in the context of environmental harms, ruled on at the court level. This would not be the case for Windsor Framework Article 2 and environmental rights if they were deemed in scope of Article 2.1 via the 1998 agreement. For an infringement of these, there just needs to be demonstrated the diminution of such a right as a result of Brexit. The diminution doesn't even have to be There isn't a qualifier for the gravity of it. It just has to be demonstrated to be a diminution resulting from Brexit, underpinned by EU law, as has been set out in the test. Before Brexit, the right to life and respect for private and family life were not just protected and given effect in Northern Ireland through the ECHR, but also through the EU Charter of Fundamental Rights, which can be significant here, which applies when member states are implementing EU law or acting in the scope of EU law. Article 52.3 of the Charter provides the corresponding ECHR and Charter rights are to be given the same meaning and scope. An argument could be made, and we do explore this further in the full research, on the basis that a greened right to life and right to respect for private and family life ought to be given at least the same level of protection under EU human rights law as the court has done in its environmental degradation jurisprudence. The added value of reliance on the EU Charter via the conduit pipe, ECHR, and the 1990 agreement RSEO would have been that it came with the full range of EU law remedies, including disapplication and state liability. Consequently, and considering the extensive contribution of the EU to NI environmental standards and governance, including through CJU jurisdiction and European Commission oversight, as well as the important role of the court case law in the field of environmental human rights, there is real potential for diminutions of relevant RSEO rights as a result of Brexit, with obvious examples being that could trigger diminutions of relevant RSEO rights, like the right to life or procedural rights, being in the field of air quality, water quality, and procedural protections and structures applicable to environmental standards. Okay, so I'm like running out of time, so I will just finish with the run through of our sort of overview conclusions. So takeaways: human rights are indivisible, interdependent, and interrelated, meaning all human rights can have an environmental aspect, including those contained in the 1998 agreement. Clean air, clean water, a stable climate, healthy soil are preconditions for the enjoyment of human rights. The RSE section of the 1998 agreement protects a broad suite of rights beyond those expressly mentioned, and there is significant scope to argue that the 1998 agreement established a wide range of procedural and substantive environmental rights and other human rights that can protect the environment. An objective of the Windsor Framework is to protect the 1998 agreement in all its dimensions, including through Article 2's express provision for protecting against diminution of rights. Because the 1998 agreement establishes an extensive range of rights and safeguards, including the context of environmental protection, purposively interpreted, this also means that Article 2 of the Windsor Framework can apply to a potentially extensive range of rights and safeguards, including potentially in the context of environmental protection. Brexit's had a significantly detrimental effect on structures and laws designed to deliver environmental protection in Northern Ireland, largely due to reliance on EU law for environmental standards pre-Brexit. Environmental rights are therefore a category that are particularly vulnerable to diminution after and because of Brexit, and our research suggests that post-Brexit diminution of environmental rights and safeguards are likely to fall in the scope of Windsor Framework Article 2 across a range of areas, and these diminutions are therefore likely to be subject to future legal challenge. But to really get into the meat and the examples, you're going to have to wait for the final report. So thank you so much.
Thank you. Thank you for jumping in and joining the panel.
Okay, so Billy has set an extremely tight turnaround, and you only have 10 minutes for coffee, so we're gonna get through the questions quick in order for people to have the coffee. If we might collect a few though, because we probably can only have one round. So if people have questions.
Thanks so much. It's Claire McCann here from the Human Rights Commission. Thanks for great presentations. I'm not going to say especially Ty, but especially Ty, given the overview from the Human Rights Commission perspective. I'm just interested in exploring a bit more about the remedies point. It comes up in all three of your different kind of pieces of presentations in a different way, and I just wondered if you could say a bit more about potential remedies and what they add in the context of Windsor Framework Article 2.
Thanks, Claire. Do we have any, or if there's somebody online, I'm not sure how we would do that. Another question?
Hi, yeah, thank you. I suppose this is particularly directed at Ty again, sorry, but I was struck when you said about how in Ishmael, one of the reasons it failed was the lack of evidence. And I think in a lot of, when we're talking about diminution, it can seem very, very obvious, but the idea of gathering evidence for the court can be a bit of a difficult sort of idea to surmount. And I was wondering, I know that Humphreys was very complimentary of the evidence that the Commission gathered. And I was wondering if you could just talk a bit more about how you went about that and what kind of evidence you used. Thank you.
There any more? Okay, so we'll pass over to the panel I'm not sure who wants to go first.
I'll go on remedies given, or then do you want to? Okay, well, the obvious thing that's added in terms of remedies is sudden impact on UK government policy, because it thought it had got rid of disapplication, and disapplication's back. And Ty's brilliant presentation set out the fact that the ECHR and Windsor Framework Article 2 do not completely overlap, but in lots of cases, an argument can be mounted under both. And you have to disaggregate those arguments, but the remedy you will win if it's a legislative problem at the end of Windsor Framework Article 2 rainbow is very different from the remedy at the end of the ECHR rainbow. And I suppose that's almost what makes Dillon and the IMA judgment look radical. These are not radical judgments. They are, in lots of ways, quite conservative interpretations of the relevant law, particularly around ideas of the scope of the charter. In the Dillon case, the court was taking a fundamentally limited view of the scope of the charter, and that's reflected again in decisions like Ishmael. These are not radical judgments. What makes them look radical is the remedy at the end of this term. And I suppose then what gets us into the next space is what happens if the Supreme Court tries to hollow out Article 2 in a judgment in a case that might come before. We know there's permission to appeal is currently before the court in these cases. And that brings us into the other remedies that are set up under the withdrawal agreement, and particularly the arbitration processes. It's not simply things that the UK government does that can amount to breaches of Windsor Framework Article 2, or things like the Northern Ireland Assembly or the executive do. It's the courts domestically take such a view of these provisions that they fundamentally limit down their scope. Will then the commissions, under their specific access to the specialised committee within the withdrawal agreement, have the means to raise with the specialised committee process the idea that this isn't being, as a UK-wide obligation, are protected and fully fulfilled because of the way the courts have taken an overly limited view of this. I don't think we're in that space yet. We might get in that space depending on what the Supreme Court does, but that opens up this secondary realm of remedies behind it.
Sort of just, obviously the remedies point is, it is very political, because what we have now is that there are two sort of, now the IMA, it hasn't commenced, so, and legacy only really affects Northern Ireland. So in those two particular cases, maybe the effect isn't, it hasn't started, but it is obviously going to be very politically contentious if you have primary legislation that's disapplied in Northern Ireland, but still applies in the rest of the UK. So that is really causing the British government a really big headache at the moment. And that's why I think we're seeing the appeals, and particularly in IMA, where the Court of Appeal has already made a decision on the same points, but they're still bringing that Court of Appeal case. So, sorry, could you just remind me of the question?
It was about the nature of the first question. It was about
Yes.
the nature of the remedies, and is that how far to go, Claire?
Yeah.
Well, open-ended. Thanks, Claire.
Yeah. So, yeah, thanks, Claire. But the Commission has commissioned remedies research, so obviously when that comes out, hopefully we'll be in a better position to advise everybody.
Thanks, Claire.
I don't know whether Ethan, you want to speak about that?
There's not tweets on that. It's the two people sitting here are part of that remedies
The
research.
third about to arrive, so
Yeah.
Sylvia can answer that when she arrives, so would say. Do you want to get the second question about the gathering evidence, or?
Oh, Gracia, so just in terms of, thank you so much for that question. It's something I would have loved to have spoken about in the presentation itself. So I'm really glad you raised that. So as everybody knows, that the IMA challenge is an own motion challenge. So that means that we didn't directly have victims. We are not an immigration practice. We advise on human rights, and we don't have the mandate to provide specialist immigration advice. So we were really reliant on our partners, such as Una provided a very helpful affidavit from the CAJ and Hills, Rainbow Migration, a charity based in the UK in London, and the Law Centre, who are specialist immigration practitioners. So we were really reliant on gathering evidence of the impact for potential and future victims of how harmful this act was going to be. So in terms of gathering evidence, we were really reliant on affidavits of real life experience of people and experience from victims or asylum seekers or potential victims who would fall under this act from those different types of organizations, such as we've got safe countries. So one of the more harmful aspects of the IMA is the removal to countries, and there's a long list of countries that they deem safe, including Rwanda, which we know, and that Supreme Court has already held isn't safe. So got very helpful, lots of very solid safe country reports to back up the evidence that removal to certain countries. The IMA include removal to countries that weren't even signatories to the UN, the Refugee Convention, which is unbelievable, and also just the impact of particularly vulnerable groups. So Rainbow Migration looks at the LGBTQI sector, so they provided very helpful evidence in terms of how countries such as, I think at one stage Rwanda, the Foreign Office had advice on there that if you're one of those groups, you shouldn't be traveling to Rwanda, yet they were then prepared to just deport people to Rwanda. So those types of evidence are really helpful so in terms of Windsor Framework, there are lots of organizations out there who are very interested in this area of challenge and who have done a lot of research and are working with potential victims of the types of challenges that you may be thinking about. So it is really helpful to approach organizations and to get in contact with the Commission, and obviously we can signpost you to the relevant organizations if that is a challenge, area of challenge that you're thinking of. Ms. Claire?
Colin said he had something to add.
Well, no, it's actually a question for you that will keep us from talking. If there aren't any other questions in the room.
You have 1 minute to help us.
Okay, I would say, assuming you're right, with park, environmental rights are covered under Article 2. If that's the case, I want to go to Article 2, paragraph 2, and the idea that the UK government is under a duty to facilitate the operation of bodies, including the Commission. What if we get into another era when North-South cooperation is suspended and the North-South bodies stop operating? If you're right, and Article 2, paragraph 1 covers all environmental rights, if there's an effort to boycott North-South bodies, could you say the UK government is under an international obligation to facilitate the operation of bodies, including those, but including the commissions, but here the North-South bodies for the purpose of protecting those environmental rights?
I think an argument could be made. I think you could draw like the Locks Agency in Waterways Ireland if we were talking about, if you could make the link to a water quality standard that's being dropped, and as a consequence of lack of functioning of these bodies, there isn't some sort of monitoring ongoing or that sort of thing. But I could also see the counter argument from the government's perspective to say that North-South Ministerial Council is under strand 2 of the agreement, and they're not wanting to interrupt the division of confidence for that, even though that they pick and choose when they do want to take responsibility in certain areas of the next agreements and not others. But I could see both sides of that. I do think Article 2.2 has not been given much attention at all. And I do think there is the possibility to if we take a generous reading and take perhaps a more ambitious approach to Article 2.2 and the underutilization of statutory bodies in 99 agreement to date, and also in view of the objective of the Windsor Framework being to maintain necessary conditions for South population, which at its current practice, it is falling short of that, albeit it doesn't have all of the tools within the text, but it is falling short of that aspiration. And so we could see more momentum and use of Article 2, and it's still, of course, covered by everything Article 2 brings with it. So I think we need to look at it more.
Okay, and